voted with their feet. Yes.
My Lords, can I just, for fear of going back over some points, just going back to the general point that we have been debating as to the nature of the equitable interest. The point I want to emphasise that tracing in equity cannot arise unless you have an equitable interest. Indeed, the whole concept of tracing is based on that, and you can see that in the Foskett and McEwen, which is in volume 4 of the authorities at tab 33, and the position is set out at 2253.
But you only have to have an equitable interest at the outset of the tracing process.
Sorry.
You only have to have an equitable interest
exactly.
at the outset of the tracing process.
Yes.
What happens at an intermediate stage may and usually is be very murky.
Yeah, but you of course, it's all premised upon your having an equitable interest. Well, I won't take up time reading it out, but it's the 2253F to 2254C, where he explains that it's not a question, there's no discretion, and he explains what an equitable proprietary right is. It starts at 2253F, goes to 2254G.
Yes, thank you.
D.
Where he ends up by saying it's a case of hard-nosed property rights.
Yes, possible.
And, of course, Elajou was a classic case where you needed to be able to trace inequity because you were tracing through a mixed fund, and that's indeed what also arises here. Now, in our submission, a point I think I'd made, but I'd just like to emphasise that the claims here against, or the rights that Sickle had against Mr. Al-Sanir were sufficient to give them an equitable interest in the trust property, because the nature of the trust was to give not merely personal rights, but personal rights with reference to property. And that's the fundamental nature of an equitable interest, that you have a personal right with reference to property. Now, the fact that the equitable right may be defeated by, for instance, the bona fide purchaser for value without notice doesn't mean you don't have the right, nor does the fact that it might be defeated by someone who acquires title in a jurisdiction which doesn't recognise the equitable right. It doesn't mean that you didn't have the interest, it just means that it is not necessarily going to survive in certain circumstances. Now, can I going back with that point to some just brief further points about Article 4 and the Convention. Insofar as the point matters, we submit that Article 4 should be construed in accordance with its natural language, that when you review the Travaux, what one finds is that although the parties were discussing declarations of trust, ultimately they decided to adopt the wording which referred to preliminary issues relating to transfers to trustees, and the position was left unclear. And if you go to Hayton in volume 9, which is the article I mentioned to you, relating to this case. It's at tab 80, sorry, wrong volume, I think it's tab 8, volume 8. Tab 85.
What page?
Page 3490.
Thank you.
And there are two points I wanted to bring out of this article. The first is at page 3491. He refers in the right-hand column to the Court of Appeal, having focused on Article 4 of the Convention, refers to its words, and then he says, on a straightforward literal interpretation, that's the Court of Appeal, held that Article 4 applies to exclude matters concerning the transfer of assets inter vivos or by will to a trustee, but not to exclude the validity and effect of declaration of trust by a settlor when becoming trustee of a designated part of his own property. This makes sense in equating self-settled declarations of trust with trusts declared upon transferring property to a trustee. The non-application of Article 4 means that declarations are governed by the trust law, which it stated, especially for the 4 later transactions, could be Cayman law. Then the next paragraph, the court, however, held that the lex situs had to govern whether or not the settlor can alienate his property, but because if he cannot do so, then he cannot create any trust of such inalienable property. And he says the court endorsed ranges. Now, just stopping there for a moment, when he says in the middle of that paragraph, this makes sense in equating self-settled declarations of trusts with trusts declared upon transferring property to a trustee. What he means by that is that if you take the case of trusts declared upon transferring property to a trustee, no one would say, except for Samba, no one would say that in that situation any issue arises as to whether under the lex situs you are able to create an equitable interest, because all that Article 4 excludes from the Convention is the preliminary act relating to the transfer. And so what he's saying is it would be very odd if you said there was some different approach because it was a declaration, a self-settled declaration, as opposed to a situation where you have transferred property. Now, he
it's
then...
a very odd paragraph because it appears to be, I mean, he makes the point that the Court of Appeal was distinguishing between a declaration of trust and a transfer of assets to the trustee, and then appears to say that it makes sense in equating the two.
No, because what you're equating, you're putting them in the same position, in that where you have what he's calling a trust declared upon transferring property to a trustee, the only thing that is outside the Convention under Article 4 is the act by which you transfer to the trustee. And so you're not concerned in that situation with anything to do with the lex situs as to whether it has a concept of trust. And he's saying it would be very odd if you said for a declaration that you said, well, somehow that is intended to have a preliminary issue, and the preliminary issue must be whether under the lex situs you could have a trust. He's saying that it would be very odd that you had a different approach.
You say you should equate the declaration of trust with the transfer coupled with the declaration of trust. It's the transfer which is caught, not the
It's only the transfer that
And if there's no transfer, there's nothing to catch.
Exactly. And then he, at page 3492, refers to the position about Article 4 in the Travaux, and he says, as revealed in paragraph 50, this is right-hand side, I'm sorry, first complete second paragraph, as revealed in paragraph 57, the Special Commission preparing the draft intended by Article 4 to exclude self-settled trust from the Convention, civilian lawyers finding it difficult to comprehend the concept of a person being able to divide his own patrimony into a private patrimony and a fiduciary patrimony, a facility which seemed capable of plenty of abuse. Such lawyers, therefore, contemplated a liberal interpretation of Article 4, so that in declaring himself a trustee of a designated part of his private assets, a settlor could be regarded in substance as transferring him such assets from his private patrimony to himself as trustee, a strange process to be excluded from the Convention and left to the mercies of the lex situs. In the final session, doubts emerged as to the effect of Article 4, but in an attempt to obtain a majority of votes to reopen the wording of the clause and clarify matters failed, many delegates no doubt being content that the lex situs would anyhow govern self-declared trusts under Article 15. Now,
so there we are.
There we are. And this is the article, I don't need to, that I mentioned it earlier.
He assumes that it's all going to be governed by the lex situs. That's looking at it through a very common law set of eyes, isn't it?
Sorry, it assumes...
He assumes that if Article 4 applies, then you look at the lex situs, but that assumes that you're talking about proprietary interests in a strict sense, doesn't it?
Yes, I mean it's...
If you were talking about a non-common law trust, lex situs wouldn't be the common law residual proper law, would it? You'd be talking about personal rights then, or rights enforceable personally.
Well, of course, what one has to remember, once you come out of Article 4, you're into the conflicts law of the forum for an issue. And that's what you've actually got to one's got to think about, is in the... I make the very simple point. When you look at the purpose of the Convention and the Travaux, and all the discussions I showed you this morning, I would suggest it's absolutely self-evident that nobody was suggesting that the question of whether or not the non-trust state had a concept of trust was something that had to be determined in any case where you had a common law trust. I mean, that it just doesn't make any sense that that was what anybody had in mind. And we've already seen some of the commentators. Can I just ask you quickly to look at volume 7 of the authorities, just to pick up at 3254 is an extract from Dicey.
Yeah.
Actually, 3258 is probably the relevant part. 3258 to 3260, and at paragraph 29012 on 3258, there's a discussion about what are the preliminary issues, and on 3259 at 29013, Dicey explains that in the second sentence that the essential distinction is between rules applicable to any disposition of property and those which specifically affect the ability to create a trust of property. The former should be regarded as outside the scope of the Convention, the latter within it. And then they give an example. And on 3260, at 29015, a similar point is made about this question of whether you can alienate property at all. And what you'll see, if you look at all of these authorities, all of the texts...
Who was the specialist editor who wrote this part?
Professor Harris.
I was going to say, it was probably Professor Harris again.
Yeah, but what you'll find is that both Professor Harris and Professor Hayton and I think Matthews, and you have the books there, you won't find anybody suggesting that the fact that assets are in a civil law state somehow prevents the trust coming into being. The only time it was suggested was by Professor Hayton in the 1987 article, and Professor Hayton has subsequently recanted that and said entirely the opposite.
Yeah, that's all in Lord Justice Voss's judgment.
Some of it is.
Well, I mean that part.
Yeah,
the Hayton change of mind. Yeah.
That's right.
Yep.
Without taking, I mean, I don't want to take up time proving a negative. We have various textbooks, and none of them.
Well, in fact, you're, as it were, throwing down the gauntlet to Mr. Hapgood to show something that's inconsistent with what you said.
Yes.
Fair enough. Okay. Yep.
Now, in relation to Article 4, no preliminary issue relating to the validity of acts by virtue of which assets are transferred to the trustee has been identified. And even if one says, well, somehow you have to, by analogy, say, well, if there is some question relating to capacity or something similar, that must be outside the convention. The fundamental problem for Samba remains that you can't actually point to any preliminary issue in relation to the establishment of the trusts. I mean, there is no question of capacity in this case. Samba is driven to say that all issues of essential validity are governed by the lex situs, but that can't be right because that's inconsistent with Article 8 of the Convention. Just worth perhaps turning up finally. Yes, if you could take volume 8 of the authorities and at tab 88 is Professor Hayton's article from 2013. This is the article, I mean, it's a very long article, on trusts in private international law.
It's his Hague lectures, I think. It's his Hague lectures.
Oh, it's his you're right. I'm grateful for that. And at 3588 in the bundle.
3588.
Yes, so this is, it's just worth showing you because is undoubtedly Professor Hayton, and it's also, this is the article in which he deals with the Rangers case, and so at 3588, what becomes very clear is that he's absolutely of the view that common law trusts can be created over civil law assets. So one sees, he says the convention, he quotes Article 4, then he says, to the extent that a will wholly or partially cannot take effect in respect of particular property, there can be no trust. Similarly, if property has not been validly transferred, there can be no trust. He says that if there's a mistake, that may prevent the trust having come into being. Then the applicable law to determine whether a transfer of property can be set aside will generally be the lex situs. Then at 3589, he, in the middle of the page, makes the point about capacity to alienate property at all must be distinguished from the capacity to create the trust structure. And then he refers to Rangers where he explains it. And then at the foot of the page, he says, in the case of a settlor declaring himself sole trustee of designated property of his, seems that if he has full power to alienate such property, he should be able unilaterally to declare himself such a trustee if the applicable law of the trust allows it. The Italian courts have recognised such unilateral declarations of trust, and so on. And we've referred you to the Italian
Yes.
articles and the authorities. And that is, in fact, of course, where you there have a convention state whose law does not contain the concept of trust, just like in Saudi Arabia. But the Italian courts have recognised that the purpose and effect of their signing up to the convention was that their court should then give effect to the common, should recognise the common law trust. Now, so, just briefly, before I move on to Article 15, I wanted to say something more about the Rangers case. Which is in Volume 1 at tab 6. And the point, I mean, there are a number of difficulties with the Rangers case, as we set out in our case, and it concerned, at best, an implied trust rather than an express trust, because the implied trust allegedly arose out of an English law contract for the sale of the future income stream, coupled with an agency agreement, in circumstances where it was said that English law implied a trust over the income stream, fixing upon each item of income as it arose. Now, such a trust is itself, as a matter of English law, somewhat unusual and indeed contentious, and we've given you the referenced guest on that. But what is clear is that until the asset arises, there is no trust. It's simply that equity imposes a trust over the asset as it arises, and until it does arise, the purchaser is entitled to equitable relief, including specific performance of the contractual obligation. So that what actually happened in Rangers is that the Scottish court refused to recognise that equitable right to call for specific performance of the contractual obligation. So that, strictly speaking, this case shouldn't have really been concerned with the convention at all, but it was approached on the basis that there was a trust, but an English law trust. But on that basis, then the correct approach would have been to apply Article 8 of the Convention to the trust. And it's not clear how, His Lordship mentioned Article 15, it's not clear how that applied. Then the further complication was that His Lordship treated the implied trust as if it were an express trust, and indeed as if there were a declaration of trust, because you see that at paragraph 33 on page 1174. I mean, he had to construct, because you can see he says, if I'm incorrect in my conclusion that Scots law applies, the difficulty which Ticketus faces is asserting a trust over the sale of proceeds that don't exist. On the assumption that the Ticketus arrangements are sufficient to amount to a declaration by Rangers of a trust over the STA tickets and the proceeds of sale, the non-existence of both is fatal to the creation of a trust. And he then says the trustor and trustee being the same person, there has to be a constructive delivery. I mean, these are all concepts of Scottish law which are being foisted onto an arrangement which, at best, in English law, was an implied trust. So it's quite difficult to see really what you can extract from it, other than, at best, the general point that he makes, which is that property, in order to have a trust, must be alienable at all under the Scots, under the lex citus. And that's the point that the academic commentators have all made.
Is there any discussion of the concept of capacity here?
In this case?
Yes.
I can't remember if he puts it as capacity.
I don't think he does.
I don't
think
It's
he-
a matter of
I don't think he does.
Although that's how Professor Hayton puts it.
Yes.
More than once.
The problem, I mean, we discussed that this morning, the
Yes.
problem with this use of the word capacity
Yes.
is that normally it means something different.
Yes.
And so what one finds in the books, and Professor Hayton does this, that they talk about capacity in the different ways. They recognise there is capacity as one would normally understand it, and then capacity to alienate your property. And we referred in our case, I don't want to take time up on it, but as I said earlier, there is a debate on capacity properly so-called as to what law governs that. There's absolutely no reason why that would be governed by the lex citus. One can see that...
Be governed by the personal law of the...
Exactly, that's what you would
person said to
expect.
back it.
I mean, if Saudi Arabia said you don't have the capacity, for instance, a Saudi Arabian woman didn't have the capacity to alienate her property, you can see that's potentially a relevant issue, because the question of whether you apply Saudi law or Cayman law, but we're not in that territory. So in our submission, that Rangers is, in many respects, an unsatisfactory case in that it wasn't dealing with trust actually at all, but in any event, it wasn't dealing with an express trust, it wasn't dealing with a true declaration of trust, or whether any preliminary issues can arise in relation to a declaration. And it's certainly not authoritative for Samba's proposition that an equitable proprietary interest in an asset can only be created if that's possible under the lex citus. So, in short, perhaps in short's the wrong thing to say, I haven't been on my feet for some time, we say Article 4 does not have any relevant application in this case, but even if it did, it would take you back to the common law conflict rules, and that wouldn't take you here to Saudi Arabia.
Right.
So the final point I need to deal with is Article 15. And again, I know I keep saying the issues are narrow, but the issue for Article 15 is, again, a very narrow one, because, and you can get that from the statement of
Yes.
facts. It's nothing to do with foreigners in Saudi Arabia, who can hold shares. It's set out absolutely clearly at page 71C.
Yep.
Is the fact that under Saudi Arabian law, there is no means of creating separate legal and equitable proprietary interests in property, a provision of the law designated by the conflict rules of this forum that cannot be derogated from by voluntary act. So you can see it's an incredibly narrow point. And once you see that, in our submission, the point is completely hopeless.
Why is that?
Because, firstly, Article 15, in fact, doesn't have anything to do with the issues in this case. And for that proposition, I rely on the decision of Lord Collins at first instance in the Re-Barton case, which you have at Volume 1, Tab 9. I think that is one of the few authorities that within the...
But is your point that Saudi law is not the law designated by the conflicts rules, or that it is a law which can be derogated from by voluntary act?
It's both. My first point is that you have to find a conflict rule, which is a rule which relates to something other than the validity of the trust, that there is none here. Secondly, even if that's wrong, you've got to find a conflicts rule which points to Saudi Arabian law in some relevant context. There isn't a conflict rule at this court that does that. Thirdly, you then have to find that there is some relevant provision of that this is the one we're looking at, namely the absence under Saudi law of a division of legal and equitable title, is something that cannot be derogated from. Just on that last point, the Court of Appeal's point and our point is very simple. There is nothing in the evidence to say that as a matter of Saudi law, you cannot enter into a trust, provide a trust of your assets governed by Cayman Island law.
Well, that's not the point, is it? The question is, looking at the formulation in 15C, the question is whether the proposition of Saudi law that there is no means of creating separate legal and equitable proprietary interests in property is a provision of Saudi law which you can derogate from by voluntary act. Doesn't matter under what law you purport to do it. The proposition of law whose derogability we are concerned with is that there is no separate legal and equitable proprietary interest in an asset.
Under Saudi law.
Under Saudi law.
But that doesn't tell you whether Saudi law allows you to enter into a trust of your assets under a foreign law.
Isn't that renvoi? Isn't renvoi prohibited under this convention?
Well,
No, that's it. You're only looking for this purpose. I mean, I may be wrong, I haven't checked. But normally these conventions are only talking about
The emphasis of renvoi was excluded anyway, because otherwise you couldn't effectively deal with it.
Conflicts rules of Saudi. That's not what you're doing.
no.
The question is exactly as the Court of Appeal said.
Sorry, but I haven't answered I'm not quite sure what your lordship is suggesting.
Well, let's just have a very quick look at
987, I don't know if Article 16 covers this. It's page
full convention
987,
is in volume
volume
2.
1.
It's volume 1.
One of the
It's
authorities.
tab 1, and Article 15 is at page 987.
I don't know if Article 16 is in point, I'm not sure.
I'm sorry.
Yeah. Yes. So, in Article 17,
17, isn't it?
it's that
17,
the
sorry.
law means the rules of law in force in a state other than its rules of conflict.
Yes.
So one's not concerned with Saudi conflict law.
Well, you were, if you're suggesting that insofar as these provisions cannot be derogated from by voluntary act, you include by a voluntary act under some other law.
Well, surely, if Saudi law doesn't prohibit you, Saudi law itself may not have the concept of, it doesn't have the concept of legal and equitable, separate equitable ownership and of trusts. But that doesn't tell you whether it prohibits you entering into a trust of your property under English law.
Well, that's absolutely common sense, but it's not the way that provisions such as Article 17 are normally
What you
interpreted.
are envisaging, surely, is that Saudi law might say, in Saudi law, you can't do this. But Saudi law has no problem about your doing it under some other law which Saudi law will recognise, and that is part of the conflicts law of Saudi Arabia.
Well, just pausing before you answer that question, you might want to add to it the second share sale agreement, page 359, that Mr. Habgood relied on, because in fact I would be interested to know whether in answer to Lord Sumpter's question, you rely on the wording of Roman 3 to be open to just that possibility, because that says Sickle can't hold legal title to such shares. The nominee is willing to hold legal ownership of such shares as nominee for Sickle in order to comply with the legal requirements in Saudi Arabia. That could be interpreted as a recognition that that is something which Saudi law would accept.
Yes, but the point is the extent to which Saudi law would or wouldn't allow that it hasn't yet been decided.
Yeah.
What is short to be done in this case is to short. That's what Mr. Hapgood had a whole laundry list of things originally, which he said meant Article 15 applied. He's now reduced it to this one point, which is that Saudi law does not have a means of creating separate legal and equitable proprietary interests.
The reason I took you to that was simply this, that you've got the Court of Appeals 53-54. Mr. Hapgood said in answer to that, well, they'd raised 4 questions, only the first 3 mattered. The answers to the first 2 were in the SFI, and 3 was dealt a knockout blow by the terms of the share sale agreement.
But
if it isn't a knockout blow, then you're left saying, well, as the Court of Appeal has pointed out, there's an absence of expert evidence.
yeah, I mean, it's not. I mean, Mr. Hapgood was trying there to short circuit points which he's actually recognised are not properly before the court, and so that he's confined himself to this narrow point which is in the statement of facts and issues, and that's the question. And whether, because Saudi Arabian law doesn't have that means of creating separate and legal equitable interests, we're at the 3rd stage of the inquiry, but is that a mandatory provision which can't be derogated from? Now, the point that I was making to you this morning is that if that were right, that drives a coach and horses through the convention and the whole discussion that took place. That's why this is complete nonsense. I showed you the discussion about Article 13. You remember where the French delegates, supported by 1 or 2 other civilian countries, were saying, we want a situation where common law countries do not recognise trusts over assets in civil law jurisdictions. And that was roundly rejected as being completely contrary to the whole purpose of this. And so the idea that this has come back in through Article 15 in our submission is an absolute nonsense.
Well, the prior question, though, is whether Article 15 applies at all.
Well, exactly. I mean, I, as it were, jumped to the end in response to Lord Sumption's point, but it doesn't apply at all. And the reason for that is explained, I would respectfully suggest, in the judgment of my Lord Collins at first instance in the Barton case in Volume 1.
Apply.
At tab 9, at page 1232. And just excuse me for 1 second. 1232, and the passage that I would rely on is at 1243, where His Lordship is considering the scope and ambit of Article 15, and at G, Mr. Studer's argument is that Article 15 requires the court to apply the conflict of laws rules relating to succession, so that the law of Texas, as the law of Sir Derrick's domicile at death, will apply. Article 15 requires the court to give effect by specific example to forced heirship provisions, which apply as a result of the law applicable to succession rights. The limitation on William Barton's rights under the will are a similar case, and accordingly provisions which cannot be derogated from by voluntary act. It's submitted that such provisions are merely the obverse of forced heirship provisions, and that they enforce the succession which has been prescribed by their testator. They too, therefore, fall to be referred to by the provisions of the law designated by the conflicts rules of the forum for questions of material or essential validity. The combined effect of Section 1.3 and Article 15 of the Convention is thus to refer the validity of any attempted defeasance of the residuary trust to the law of Sir Derrick's domicile, i.e. Texas. In my judgment, this argument cannot be accepted. the purpose of Article 15 is to preserve the mandatory effect of the rules of law designated by the conflict of law rules for matters other than trusts. And that's the fundamental point. An example of such a rule is that the matters of succession to personal property are governed by the law of the testator's domicile at death. If he's domiciled in a country which gives indefeasible rights of succession to children, then the relevant rules of the country must be given effect, notwithstanding the creation of a trust which purports to override those rights. But in this case, there's an insuperable hurdle to the application of Article 15. The only possible relevant reference to Texas law required by the English rules of conflict is to Texas law as to the domicile of Sir Derek to determine the essential validity of the will. By that law, the will is valid, and so on. And in our submission, the Article 15 cannot operate to prevent the creation of the trust interest. It's concerned with something other than the validity of the trust itself. That's clear from Barton. Cheshire.
How do we get that out of the language?
Of Article 15? Yes, you do. You also...
But how? Can you just... Doesn't prevent the application of provisions of law designated by the conflicts rule of the forum, which we assume for present purposes is Saudi law, because otherwise Article 15 doesn't arise, insofar as those provisions cannot be derogated from by voluntary act. And then there are some particular but non-exclusive examples.
Perhaps the answer is it has to be designated by the conflict of laws rules. And what you're saying is that there is no, in this case, there is no conflict of laws rule that designates the lex situs.
Well, we do say that.
Obviously, the Article 15 point really only arises if the lex situs is a Saudi Arabia and that law governs.
Yes.
So that's the premise on which we're considering Article 15.
No, but because you're first, we're considering whether Article 15 applies, aren't we?
My submission is it doesn't apply at all to... I mean, does Article 15D apply at all? In my submission, it doesn't apply for two reasons. In my submission, Article 15 is not concerned with matters firstly relating to the validity of the trust. It's because that is all governed by the law of the trust under Article 8. Secondly, 15D is not concerned with the transfer of title to property to the trustee. That is taken outside the convention by Article 4. So this is dealing with something else. What it's dealing with is transfer of title from the trust downstream.
But I mean, we actually...
And that, I'll show you, Von Overbrook says that. What?
With the introductory words of 15.
Yes.
Because A to F are specific examples, no doubt in practice likely to be the most important ones. And the introductory words say that if there is a provision of the law designated by the conflicts rules of the forum, and let's assume for the moment that that's Saudi law, if there's a provision of Saudi law which can't be derogated from by voluntary act, then the convention doesn't prevent...
No, my Lord, with respect, there's a logical flaw in what you're saying. And the logical flaw, I don't mean that disrespectfully, what the convention does is it provides a conflicts of law rule in relation to trusts. So what Article 15 is intended to make clear is that the convention conflicts of law doesn't in any way prevent the application of other conflicts of conflicts rules of your forum, which relate to other matters, and that's what it's making clear. Because it would make no sense if you said you have that what you have here is a conflict. The whole convention is about conflicts of rules, so it makes no sense to say we've got this convention defining conflicts of rules, but then we're going to have another rule which provides that you apply your conflicts of rules, conflicts of law rules before we had the convention. That's not what it's doing. It's saying things that are not covered by this convention, then this will not affect your conflicts of law rules in relation to these matters.
But they wouldn't be affected by the convention anyway.
No, but that's all it's intended to. It's just, if you like, this is something to making that clear.
Can you just repeat what the things which you say are outside Article 15 or not dealt with by it? The validity of the trust, because you say that's dealt with either as a matter of capacity or by Article 8.
Yes.
And what was the other thing? Transfer of title?
Well, transfer to the trustee is outside the convention because of Article 4.
Yeah.
And so Article 15D is plainly not dealing with transfer to the trustee, because that is outside the convention anyway, and that's governed by your conflict of laws of the forum.
But validity, it could be, couldn't it, an overlapping provision? You get
No,
within the convention, you apply prima facie the law of the specified by Article 6 or 7 to decide validity, but if there are provisions of some other law which would be designated by the conflicts rules of the forum, and those have provisions which can't be derogated from by voluntary act, then Article 15 applies?
No,
That's
not
right.
to validity, no. Because you look at the shopping list of things that they particularly are talking about.
Yes.
The protection of minors and incapable parties, the personal and proprietary effects of marriage, succession rights, indefeasible share of spouses, protection of transfer of title to property, protection of creditors in matters of insolvency, protection of others in other respects of third parties acting in good faith. These are things other than points relating to the trust itself and the validity of the
Well, there are matters that may be affected by the trust, unless Article 15 allows the conflicts rules of the forum to prevail over that.
I see that the opening words, that the words Mr. Justice Lawrence Collins used about the purpose of Article 15 to preserve the effective rules of law designated by conflict rules for matters other than trusts, is in fact in Overbeck's report.
That's what I was going to go to next.
Right.
Von Overbeck at
1046.
yes, 1046 in this bundle. Yeah, it starts and he explains at Article 15 at paragraph 136.
So what page are we on?
1046.
1046.
No.
Paragraph 136 explains that the first paragraph of this
36.
provision preserves the mandatory rules of the law designated by the conflict rules of the forum for matters other than trusts. And then on 1047, paragraph 138 says it will be recalled that Article 4 removes entirely from the Convention's coverage the acts done prior to the creation of a trust, which are necessary for its creation. To the contrary, Article 15 looks to those hypothetical situations in which an existing trust may deploy effects which are incompatible with the mandatory rules of the forum or the law of the third country for a field other than trusts. Yeah. And the attempt was to preserve above all the forum's substantive law in cases where its conflicts rules designated its own. And then he deals at 1048 specifically with the paragraph that we're concerned with, which is D.
Paragraph 148.
Sorry, page 1048.
Beg your pardon.
At paragraph 143.
Thank you.
Just under that, on the right-hand side, it's the
Yep.
heading, the transfer of title to property.
Yep.
And he says, for its part, the German delegation proposed to speak in a broader fashion simply of property, The German delegate hoped in this way to avoid having a separate subparagraph dealing with the protection of third parties. During the discussion, a reference to rights in rem or to property in general met with opposition, for it seemed to go too far. It was thought that property rights, being an essential element of every trust in the common law countries, such a reference would contradict the provisions on recognition. Thus, this idea was not accepted. In contrast, it was decided to make reference to security interests and so on. And so, in our submission, that you have to find, as Lord Collins said, a relevant issue which raises a conflicts of law. Here, there isn't anything relevant. There's no English conflict rule which would designate Saudi Arabian law as governing the issue or any other aspect of the validity and effect of the trusts. But even if that is not correct, in our submission, there isn't any mandatory provision of Saudi Arabian law. The absence of the concept of common law trust and any distinction between legal and equitable interest is not, we would suggest, a provision, nor can it possibly be said to be a mandatory provision of Saudi Arabian law. Now, there's very little guidance in the authorities on what is meant by a mandatory provision, or a provision that cannot be derogated from by voluntary act. We referred you to a decision of Mr. Justice Blair's in the Commercial Court, where he considered a similar provision under the Rome Convention. The essential point that I would draw from that case, it's the Banco Santander case, but the essential point that he makes, which I would suggest is right, that you, when considering this, you have to, what you're doing is interpreting this convention, and what you have to ask is, under this convention, is it intended that the absence of the concept of a trust or separate legal and equitable ownership under the lex citas, is that something that was intended, would have been regarded as a provision which cannot be derogated from by voluntary act? Now, I think part of the
Your
answer...
submission effectively is that this is concerned with the knock-on consequences which the existence of a trust would have on matters other than trust law,
Yes, exactly.
e.g. the mandatory rules of French law as to rights of inheritance.
Yeah, exactly. That's,
Yes.
in a nutshell, that's it. That's why
Yep.
this is completely irrelevant.
Yep.
I think, sorry. Yeah.
That's exactly what we
Yes.
Yep.
The point that's made to me is that it's not there's no question of renvoi here. What Samba has to point to, even if we say none of this applies, but
Yes.
even if it did, they'd have to find something in Saudi domestic law which prevented Al Sania doing something under foreign law. And we've given you the example of Bodley Head and Fliegen at A6 tab 59 as an example of such a domestic provision. There was a Saudi domestic law which prevented natural persons entering into foreign law governed obligations.
Russian. Solzhenitsyn, wasn't it?
Yes. Sorry, what did I say? Russian, I'm not sure. What did I say? Saudi, sorry. Sorry.
You're running into time.
Yes. So, my lords, we say the Court of Appeal were right. Can I then just say, we also therefore say that the point raised by Lord Sumption this morning as to whether or not there's a different way you could put the case doesn't, for our part, need to arise. But can I explain the difference between our case and the suggestion that Lord Sumption makes? The way we put the case is we say we had a proprietary, we had a right of property as defined in the Insolvency Act. Therefore, any further dispositions were void. That we don't have to plead anything about Samba's knowledge. It will be for them to plead by response if they say they were acting bona fide and so on. If we were going to proceed by way of alleging a constructive trust of some sort, we would probably have to allege some knowledge on their part, wrongdoing and so on. So at this stage, we haven't done that. If you were against me, and my submission you shouldn't be, but if you were against me, the result would be that the order of the Chancellor would be reinstated, which would stay the action. It would then be for us to decide whether or not, at that stage, we wish to amend the claim and to seek leave to lift the stay. But I'm not asking you to express any view on that. I'm not saying that's what we would do. But it would seem to me that the way in which one, as it were, could deal with the matter, if we considered it appropriate, would be that way.
Yes,
Not asking you to do anything.
Very well.
So, my Lord, unless I can assist you further, those are my speech.
Thank you very much indeed, Mr. Howard. Thank you. Mr. Bramble. Mr. Hapgood.
Yes, may I please your lordships? May I start with what I regard as being really the fundamental battleground between my learned friend and I. It partly goes to his citations from the Travaux, but it mainly goes to why he cited that, because what he has done is he has consistently mischaracterized our case by saying that he says no one in all these discussions ever suggested that a common law trust could not extend to civil law assets. And in effect, he's saying that is what my case is. Now, in that, he is profoundly mistaken. Our case is as follows. A common law trust may apply to common law assets and assets in civil law states, and such trusts have existed for decades and decades. But if the assets are in a civil law state, then the beneficiary will not get a proprietary equitable interest. And you have seen really quite a lot of material to that effect. There's our Annex 2 in our case, which I've already shown you, dealing with the position in Italy and the Netherlands and Switzerland.
You said if the beneficiary is in a civil law state.
No, the assets.
Are the assets?
Yes,
misheard you.
yes.
Right.
And can I give you some insight into, a bit more insight into the Italian trust interno? If you please go to the article of Authorities, Volume 7, tab 67, page 3096. And this is an article by Alexander Braun on Chapter 15 of the International Trust, edited by David Hayton. And at page 3104, paragraph 1533, so far as a choice, 3104, so far as a choice of law is concerned, trust interni are most frequently governed by the law of the jurisdictions such as England and Jersey. And then if we go on to 15 47 at 3109.
Yeah.
One of the main implications of the trust is the trustee holds a trust property, but the trust assets are separated from its personal assets. This is also established by the Hague Trust Convention, Articles 2 and 11, which state that trust assets constitute a separate fund. It's been claimed that this feature of the trust is contrary to a fundamental principle of the Italian legal system, the unitary notion of ownership as set out in Article 2740 of the Italian Civil Code. And then developments in Italy are discussed. And at page 3111, under a heading, the numerus clausus doctrine, the numerus clausus is another principle which has been considered an obstacle to acceptance of the trust in Italy. It's been suggested that incorporating trusts into the Italian legal system necessarily entails recognition of two different kinds of property rights. In other words, it would introduce a partition between legal and beneficial title, but because Italy admits only a limited catalogue of property rights, it would be impossible to recognise a trust in turno. Such reasoning was applied by the Tribunal of Belluno in its judgment of 25th September 2002. However, this argument has been gainsaid by the opinions of all other courts which have declared that the trust does not give rise to a split of property rights. And it gives the example of the Tribunal of Bologna, then in paragraph 1555, the Tribunal of Bologna again, and then 1556, that the trust does not create a new kind of property right, and that ownership of the trust asset is not being split, has been confirmed by the Tribunal of Venice. According to this court, the creation of a trust simply determines the transfer of assets to which certain duties of administration are connected. This view was shared by the Tribunal of Florence, which in its judgment of July 2, 2005, confirmed that a trust does not give rise to a split in ownership of trust assets. For the court, there's only one legal owner who is a trustee, a position also adopted by the Tribunal of Velletri. So to suggest that that we have in any way advanced the case dependent upon the proposition that a common law trust cannot be created over assets in a civil law jurisdiction is a complete fallacy. I was asked by Lord, or Mr. Howard was asked by Lord Neuberger whether he was throwing down the gauntlet for me to cite a passage. I mean, I think the clearest one is AV9, tab 101.
Yes.
It's page 3886.
Thank you.
Current edition of Underhill.
The one we looked at, is it?
Yes, and it's
10.13
10.13, yes.
that we looked at, yeah.
Yeah, that exactly sets out my position.
Thank you very much.
Sorry, which page is that on?
3886.
I see.
Now,
Effectively, they'll be treated as the nearest possible thing.
yes,
Segregation of assets or patrimony or something like
yes,
that. Yeah.
yes. Now,
Or in Saudi Arabian law, whatever the institution was which we saw,
Amana.
Amana.
yes, Aman, yes. Yes. Now, Mr. Howard covered a very wide range of territory. I'm not going to go over anything like all of it. I just want to pick on two more points which I think are important in the context of things. The first is the question of property and its statutory definition. And I say the important point for this purpose is to understand the case which we have been called on to meet. And may I give you some references? This is in the amended points of claim, core volume 2, starting at MS page 270, page 276, under a heading D, the relevant securities, paragraph 20, a significant number of securities held in the name of Mr. Al-Sania were owned by Sickle. And that must mean beneficially owned, because it's common ground they didn't have legal ownership. Paragraph 22, the documents demonstrating that the relevant securities were held in the name of Mr. Al-Sania but were owned by Sickle are set out in the following paragraphs. Heading F, at page 283, the September transfer was a transfer of Sickle's property. Paragraph 37 on the same page, in the premises, the September transfer of relevant securities was a transfer of assets owned by Sickle. Then paragraph on the next page, 284, paragraph 41.6, the September transfer of relevant securities was a transfer of Sickle's property. 41.7, another reference to a transfer of Sickle's property.
It's a bit unreal, isn't it? I mean, if you'd asked Mr. Al-Sana, whose assets are these, who owns them, he would presumably have said, well, of course they're Sickle's assets. If somebody had said, oh, well, that creates a bit of difficulty because technically in Saudi Arabia, these are Saudi Arabian shares, he would have, everyone would have regarded the trust instrument as the dominant instrument between Sickle and Mr. Al-Sana.
Well, that's the question.
Wouldn't they?
Well,
I mean, I'm just trying to look at it the way round it
Yes.
would be looked at once you entered into the trust.
well, I can think of all sorts of ways the conversation might have gone.
All right, well, certainly if they're taking your advice.
He might have said, good I can now sell them with impunity to Samba.
Mine or mine.
Yeah.
But I'm now going to the prayer for relief at page 286. The first prayer relief is a declaration under section 127 that the September transfer of relevant securities was a void disposition of Sickle's property. Now, the only fair reading of that pleading is that the property is a beneficial interest in the shares. Beneficial interest in anything else doesn't matter, because the only thing which Samba acquired was the shares. So this whole debate about what the property was really comes down to a rather empty and semantic debate, in my submission.
Well, it's more refined than that on your case, isn't it? The only thing that they acquired was the legal interest
Yes,
in the shares.
yes.
And the question whether
Well-
what, if any, equitable interest subsisted would then depend on notice.
Yes, and that would get you into a different series of questions, as Lord Neuberger outlined
Indeed
first,
it would.
first thing this
Get you
morning.
into the point which I raised at 10:30 this morning.
Yes,
which is not
quite,
part of-
yes.
which is not part of this appeal.
Which thankfully is not part of this appeal, yes.
There's nothing else you want to say about that aspect?
No, there's nothing else I want to say about that, thank you. Now, the next point is on Lex Citus. I mean, the starting point is that this goes to a question Lord Mance raised yesterday. The Lex Citus of a beneficial interest is situated where the interest itself is situated. if we look at, can I just show you Underhill on this? And wait,
Circular.
Yes.
yes, situated where the property is situated. Underhill, AV Authorities Volume 9, tab 101, back to there.
Page.
Page 3915.
Thank you.
And it's para 100.128. A beneficial interest under a trust is located where the trustees of the trust might be sued to enforce the terms of the trust. This will apply if the claimant has at present only a right to enforce the trust and not an interest in possession. An interest in an as yet unadministered estate is located in the place where the estate ought naturally to be administered.
Yes.
However, if the claimant asserts equitable ownership of property held subject to a trust, that equitable title is located where the property which is subject to the trust is itself located.
Right.
Nearly all tax cases, aren't they?
Yes, but none the worse for that. So, Sickles' alleged equitable priority interest is situated in Saudi Arabia. Now, if we then move to the question of lex situs more generally,
But if it's I mean, does this slightly beg the question? If all you have is a bundle of rights in respect of property which can't be the subject of any split interest in Saudi Arabia, wouldn't those bundle of rights be located elsewhere? Wouldn't they be located at the place either where the trustee is or at the place where the trust is located?
well, unless you conclude that they don't exist at all, because they can't exist.
Well, no, there must be some rights. I think you accept that there are, at the very lowest, if there are not proprietary rights, there are personal rights.
I accept that, yes.
Yes, and they would be located either where the trustee is or where the trust is.
Yes.
You always have to ask for what purpose is the question being asked, where they're located.
I mean, the paragraph you've just read us, 100.128, is concerned with the proprietary equitable interest, is it not?
Yes.
Where there may be another location for the personal, effectively contractual right, or the personal equitable right.
I'd like to just touch on the point that was made on Westdeutsche Landesbank,
Yes.
which I think commends itself to Lord Collins in particular. Can you get the reference up, please? I mean, that opened the way for an friend to construct really a very simple case of saying, well, if you have a beneficial interest, you have a proprietary right. That's very much it. There it is, yes. Yes, the passage you were taken to is in Authorities Volume 6, tab 64, page 3030. And it's Proposition 4, you'll recall. Once a trust is established, as from the date of its establishment, the beneficiary has in equity a proprietary interest in the trust property, which proprietary interest will be enforceable in equity against any subsequent holder of the property, whether the original property or substituted property in which it can be traced, other than a purchaser for value of the legal interest without notice. Now, the point I make is that that statement must be read in context. It was not in any way concerned with complications arising from the fact that an asset is located, it's cited in a jurisdiction in which you cannot split the legal and equitable interests. And useful as it is as a statement of English law in relation to English assets, or indeed assets in any other common law jurisdiction, in my submission it just doesn't help on the particular facts of this case where the assets are Saudi Arabian. I submit you get no help at all from Webb v. Webb. The short point is that the son was a trustee, and he was being held accountable as a trustee who had purchased land for his father. We are not a trustee, and we are not Sickles' trustee. In fact, we have no dealings whatsoever. So it's a completely different situation.
As I understand it, that's not an issue.
That's,
Not an issue on this appeal.
I think that's right, yes.
Now, there may be an issue hereafter about notice,
Yes,
which would affect
if we get into...
the correctness of what you just said.
Yes, yeah. If we get into bona fide purchaser for value, I suspect there might be an issue afterwards. So in the end, I come back to what I regard as the foundation of my appeal, which is the decisions in Macmillan and Rangers. I want to make one point in reply on Macmillan. My learned friend sought to distinguish it on the grounds that it was a case about priorities. If I can show you what in fact happened in the case, it's Volume 1, AV Volume 1. Tab 7, MS 1214. Now, this is in the judgment of Lord Justice Aldous, and at letter G on 1214 he said, he's having cited Cadie's case, he said, it's true that Thorson J was not dealing with a question of priority of rival claims to shares, but he was concerned with rival claims and concluded the appropriate law was a law of incorporation. If that be right, as I believe it to be, then it would be odd to apply a different system of law to resolving claims to title in which the issue was concerned with priority to title, to that applicable where the issue was whether a particular person had any title at all. And therefore, for Mr. Howard to seek to brush aside Macmillan on the ground it was concerned with priorities, when in fact Macmillan said it makes no difference that we're concerned with priorities, is a very, very weak ground of distinction. And then finally we come to... Yes, and the Court of Appeal agreed with that in this case. That is, that's Lord Justice Voss at MS 239. Paragraph 53. Yes, paragraph 53 of the judgment.
Thank you. Yep.
Now, finally on Rangers, heard my submissions on the judgment of Lord Hodge. And what has happened in this case is the Court of Appeal, in paragraph 51 of its judgment,
Yeah.
at page 238, it's created a gloss on the judgment. It's imposed a capacity test, a capacity to alienate at all. And as my Lord Sumption said this morning, well, capacity is simply an aspect of impossibility. So even if it were to be a good test, I would still be able to set up a case of incapacity. But ultimately, I say that your Lordship should reject that gloss on the Ranger's case, because it leads you to what I say is a sort of irreconcilable statement in paragraph 55 of the judgment, which I took you to yesterday, which is that the rights in respect to the shares will have to be determined by the governing law of the trust, taking into account that under Saudi Arabian law, a division of equitable and legal interests is not possible.
Why is that inconsistent? You're operating under Cayman Island law. You have to take into account the reality, namely that you couldn't make an order for a division of interests in Saudi Arabia. You could make other appropriate order for realization of any equitable interests. You could make an in personam order for sale.
Well, I'm not sure that's right, because in the sentence 4 where I just picked it up, Lord Justice Voss says, to put the matter in the context of this case, the declarations of trust will not be dividing
Yes.
the equitable and legal interests in the shares under Saudi Arabian law.
Yes. Well, and so he's merely repeating that. The caveat refers back to that, doesn't it?
Well, insofar as he's suggesting that you can both at the same time recognise that equitable and legal title under Saudi Arabian law are indivisible, and that you can make an order on the basis that they are divisible, then I say that's irreconcilable.
What he's saying is that the trust has one thing, and you have to give effect to it in the best way you can, bearing in mind the shackles imposed by Saudi Arabian law.
Well, I say that's not an unsatisfactory solution, and that you've just got to come off the fence about it.
Yeah.
And also, those are my submissions in reply.
Thank you very much indeed. Anything you want to, any other notes you want to raise? Thank you very much, Mr. Appellant. Hope you're feeling better. Hope you're feeling better.
Thank you, I am thinking.
Good. Good. Well, thank you very much indeed for your submissions, both orally and in your written cases. We will consider our decision and let you know in due course. The court is now adjourned.